Hi, everybody. I hope you're having a good, what day is today? A good Sunday so far. If you can't hear me, let me know. Um, my AC is really loud, but I definitely have to have it on right now, which is why I haven't been going live as much because my AC is just so loud. But I think I've gotten it a little quieter now. But I hope you guys are having a good day. But today I am trying to finish up, well, I'm trying to finish up a lot, but right now I'm trying to finish up my property law flashcards. I've about 25 left, and I needed some motivation. I almost took a nap, and then I was like, maybe I'll just do a live. So, hey, Maury. Oh, it's good to see you. Did your notifications go off? I feel like I get notifications. I never get notifications that I want. I always get notifications for lives that I'm not interested in. And then, like the people that I want, I don't get the notifications for. I'm glad you found me though, because yeah, I definitely needed some supervision today. Um, my deck, how many flashcards do I have here? I think 75. I think I'm on 50. Um, yes. Okay. So, lovely subject of property. Property was actually my best grade. I think it was one of my best grades in law school my first year. Most people do not like property. I'm not liking property right now because I'm way over this, but I take the test on the 28th, so it's kind of crunch time. Um, okay. Um, okay. Right. So what is a purchase money mortgage? A purchase money mortgage is mortgage when, well, basically the loan money goes straight to the seller, third party. Um, okay, yeah. Um, if well, hold on a second. See, sometimes I have to ask Google some things. Is that right? I've never gotten a mortgage, but now I'm wondering, well, does a regular mortgage does the money just go to your bank account? Is that what's different? Oh, got it. No, I don't think I have it. So a purchase money mortgage is money used to purchase the property. A regular mortgage is you already bought it. Okay. I'm not gonna ask too many questions because that's gonna fry my brain right now. Oh, thank you, Maury. I knew I needed an adult here because I was like, I know someone knows how mortgages work. Mortgage payments are paid to the lender, right? And then, but then when they give you, where does their money go? Do they put it in your bank account or do they send it straight to the person you buy the house from? That's the part I'm confused about. Uh, But either way, at least I know that in a default or foreclosure, oh, oh, I'm okay. I think I was confused and now I'm unconfused. Okay. Foreclosure, purchase, money, mortgage, um, takes priority in getting paid off. I see. Okay, okay. Now I see where I was confused. They pay the seller. Thank you, Maury. This is why I need supervision. Okay, that makes complete sense. I got it. So a purchase money mortgage is like your first mortgage, the mortgage to buy the property. Legally, a regular mortgage, which is annoying, but like a regular mortgage is when you're taking it out, taking loan out on property after you own it for improvements or whatever. Okay, understood. Got it. And if you default and they foreclose or there's like a foreclosure sale, the profits from that sale, they go to first the person who lent the money to buy the property, and then they go to other mortgages or liens. Yes, yeah. And then they go to junior interests, and then they go to the borrower. Okay. All right. If multiple purchase money mortgages, priority goes chronologically. Okay. Okay. So if you buy a house, whoever gave you the money to buy the house is going to get paid if you default. Then, if you took out a second mortgage, they'll get paid. Then, any other liens, then you get paid. Okay. Whew. If a buyer is purchasing property in installment land contract, when does she obtain legal title? At delivery? Yes? No. Okay. Purchase property on installment plan. Buyer has legal title upon the last payment. Okay. So an installment plan means you're not going to own the property until you make that last payment, and then you do. Okay. Thank you, Maury. I seriously don't know how the mortgage stuff, like loans, all of that, like really, I don't understand. And it's funny because, like my professors that I'm like close with, they all tell me I have a really like contract minded brain, but as soon as like numbers get involved, I get very, very confused. It really is like as soon as banks get involved, I get very confused. Thank goodness they took tax. Oh my gosh, they took tax off the bar. I was terrified. I had to take federal tax. I did not take that class. It's a good class to take. I should have taken it for like the, I mean, 100% should have taken it just for the knowledge because it's good knowledge to have. But it is such a brutal class. Like I could just not bring myself to do it. But thank goodness it's not on the bar anymore. Okay, my next one. Okay. So if a state, so if it's a lien theory statute state, that means that a mortgage mortgage doesn't affect a joint tenancy. In a title theory state, it's converted into a tenancy in common, right? Yes. Mortgage. severs joint tenancy and converts into tenancy in common. Okay. What is a mortgage? A loan that you use your land as security. Yeah. Mortgage. Use land as security. Use land to secure payment of debt. Okay. 25 flashcards now. What are the prerequisites for creating an easement by necessity? Okay. So, easement by necessity. That requires 2 parcels of land to have been joined at one time, and one is landlocked. Yes, I think so. I don't like how sorry, I'm not talking that much because I don't really like how my property flashcards are worded. Yeah. Okay. So easement is when you own property or someone owns property and they're allowing someone else to use a portion of that property for like a specific reason. Okay, so you can get an easement by necessity. So that means like even if the person were to say no, you could still like go to the court and say, no, I need to use their land for this reason. You can get an easement by necessity if the 2 land parcels were at one point combined. The need for an easement arose when they were severed, meaning at one point it was one big piece of land, but now that they've split it into like 2 or multiple ones, now they're separate they're separate parcels, and you need permission from the owner of each to use either one. And they have to have strict necessity, meaning basically like you're landlocked. So this happens a lot if like, well, if you buy like a parcel of land that's just surrounded by other land and you don't have access to a road, you're going to have to get permission from like a neighboring person's land to use the road. And sometimes this happens with like waterways. There's been times where they've said like it's not really necessary because you can get to your house by boat, even if you're landlocked. So, depending on like where you are, it's really interesting what required like what is considered like necessity. Landlocked or virtually useless without easement. Okay, so the easement by necessity, they had to have been once combined. The necessity arose when they were severed, and it's a strict necessity requirement. Okay, got it. What happens when an attempt to create an easement fails due to the statute of frauds? Oh, it becomes a easement by like an implied easement? No. So that question probably didn't make sense. So easement isn't written down. Yeah, basically. If it's not written down, it becomes a license. Or okay. I'm thinking of how to say this. So easement more than, I'm going to say more than a year and not written down, or signed, or parties identified. Okay. What is a landowner's liability if he excavates land and causes the adjacent undeveloped land to collapse or subside? They are strictly liable no matter what. So, if you excavate and cause neighboring land to collapse, subside, you are strictly liable, which just means automatically liable. It doesn't matter if you meant to do it, not meant to do it, didn't know it was going to happen, didn't know it was going to happen. If you caused their land to cave in, then you were just 100% going to be liable. Okay. What are the 4 doctrines that govern groundwater rights? Okay. Well, let's first define groundwater. Groundwater is natural, flows or lies under the surface, and percolates or naturally gets to the surface. Natural water flow under surface and either naturally or by a well, or gets and reaches surface land naturally or by well. Okay. Now, what are the doctrines that I know percolates? I hate the word percolates, but it's actually like I low-key think I have to use in this definition. It just makes me think of like the funniest songs. Okay. Ooh. All right. Okay, this one I'm going to have to come back to offline because that one I think I got to look into a little bit more. Okay, but that is what groundwater is. What are the 2 doctrines that govern rights a landowner has to take water that flows through or adjacent to their land? Okay. Water flows through or adjacent to land. You can, okay, if you're in the eastern US, apparently they like to follow the reasonable use is allowed. If you are in the western US, apparently they prefer who gets there first. So first in time, first in right. Rights can be sold. Water rights cannot be sold separately. Well, that makes sense how people are making lots of money off of water. Okay. In the West, rights can be sold separately. Okay. Like coffee, exactly, just like coffee. When are you liable for changing the flow of surface water? All right, this is also something I'm going to have to look up later. Okay. I do not like the water ones. What is the fifth unity unique to a tenancy by the entirety? I know that one. I'm not going to do it. A life estate. Yeah. Okay. A life estate is ownership measured by the person's life. When they die, title reverts to the original owner or the remainder then, the heir or person. Well, it is the person that the grantor said would get it after the first person dies. So, like, if you say, I give this house to Sarah for as long as she is as alive, and then it should go to Bill. Okay. When is a life estate pour autrui? I don't know how to say that. Life estate pour autrui is when you transfer a life estate to someone else, right? Oh no. Life estate measured by someone else's life. So Sarah, like this land should goes to Sarah for as long as Bill is alive. And then, well, if you don't say anything, then you get the land back after Bill dies. That's a good way to make sure somebody stays alive. Like, say, like, you can only have this money or like this something as long as you keep this person alive. If you grant a life estate but do not, okay, you have possibility of reverter. Yes. So if you have life estate, after grantee dies, then reverts back to the grantor. And this is called reversion. Yeah. What future interest is retained when a fee simple determinable is conveyed? So fee simple determinable is when you give someone land for a specific amount of time. So like you have this land as long as it is used as a farm. And then whenever you stop using it as a farm, then it what was I gonna say? Then it's not you don't have ownership anymore and it goes to someone else. And this means it would go to possibility of reverter back to grantor. It's called fee simple. Fee simple just means like a ownership, just what you would think of like regular owner of land. And then determinable means it's not forever, it's for a determined amount of time. Right of re-entry is when the grantor of a deed can step in and either take back the property or convey it to someone else after something has happened. Yeah, nice. Right to re-entry. After a fee simple subject to a condition subsequent, grantor can take property back or convey it. It's okay. I've had family in these types of arrangements. A new spouse can live in the home after the owner dies, but it transfers to the owner's children after she passes. Oh, that makes sense. That makes a lot of sense. Yeah, that actually makes sense because almost so many of the property questions that we get for practice, um, are a lot of them are like family things, like um, like skipping a generation, like grandma to like granddaughter, or like to like the oldest sibling or cousins. So that makes sense actually. Um, which is a majority rule? That's a good question. Lien theory is the majority rule. So most states, if you have a joint tenancy and you get a mortgage, it is not going to affect the joint tenancy, and it's only a lien on the property instead of the mortgager or the mortgagee becoming a tenant in common. Um, Mortgagee holds title. If a co-tenant rents out the property, how do you split profits among all co-tenants? Mm, is it just by proportion of ownership? Yes. But you have to. So if you're a co-tenant renting, really, or making profit, but definitely renting from property, you have to disperse profits among other co-tenants in proportion to their ownership percentage. I get, but there's a lot of questions that are like someone who's like not who's renting out the property but isn't telling like the brothers and sisters or something. Um, she can't sell it, but the deceased husband wants her to have a home. That makes sense. That makes a lot of sense. What is an ouster? An ouster, if I remember, is when you are tenants in common, co-tenants, and one is in possession, one is not in possession, and you don't let the other one take possession? Yes. Um, one co-tenant, well, let's just say co-tenant refuses access to another co-tenant, and ousted co-tenant, well, let me just do this. You can seek an injunction, which an injunction is just, instead of money, you're controlling someone's like behavior. So you can seek to make them let you in, or or and recover value of, well, loss. Well, no, it's actually the value of using the property for that time. Okay. What remedies does a tenant have when a landlord breaches the warranty of habitability? If a landlord breaches a warranty of habitability, and they do that by basically like breaching the codes, or not complying, like housing and safety codes, you can withhold rent and then file breach of contract. I don't know. Kind of. Okay. So I knew that you could refuse rent. You can refuse rent, or have landlord fix the problem and reduce rent, or constructively evict. And when you constructively evict, that means that it's not the landlord evicting you out, but the situation is so bad that it's just like getting evicted. And if you do that, you have to give notice and actually leave the property. Okay. And this constructive, if you ever see that in law, that's when anything that's constructive, it means it doesn't technically meet the requirements, but it's treated as the requirements. Another one is like, what's trying like constructive conditions. Like maybe you have in a contract, like maybe you haven't written or spelled out what the like process you're going to deal with this person is like, but you've been doing it for a really long time. Um, Something can become like part of the contract, even though it's not in there by words, because you've been doing it for so long, you've been treating it as part of the contract. And same thing with the constructively evict here. Just means you're not actually getting evicted, but it's so bad living there for whatever reason that you might as well have gotten evicted. What is a promise by the landlord to not interfere with the tenant's possession? I think that's the quiet enjoyment. And you get it in every lease. And it's only basically when they don't let you possess the premises. Okay. So landlord breaches, well, prevents possession of premises. That is a breach of quiet enjoyment implied in every lease, meaning well, just what it means is implied. It's not written in the lease that you are getting quiet enjoyment in your lease, but every single lease has that. What I don't remember is if it is waivable, because you cannot waive the warranty of habitability, the housing code warranty, basically. So you can't say it's like you can't say, like the landlord can't say, oh, they told me it was okay if they didn't have heat. Like that's not okay. But I don't think this one is waivable either, but I have to check. Can you waive warranty of quiet enjoyment? Yes, you can. Okay, it is but waivable. So I guess you can tell landlord, I consent to not having quiet enjoyment or possession of the property. What is an actual eviction? Well, that's when you are actually removed. Yeah, versus the constructive eviction. Let me just start a new slide. Oops, sorry for that noise. Actual eviction. Landlord removes tenant from property, terminates lease. Well, that terminates lease and ends obligation to pay rent. What is constructive eviction? I've already done that. Well, I guess I can do it again. So eviction is when landlord breaches a duty to the tenant that substantially interferes with use or enjoyment. The sheriff comes knocking. Yeah, that's an actual eviction. Um, what is a landlord liable for? Um, they're liable for injuries that happen in common areas open to the public, and any like dangerous hazards. No, that's not what, well, I know that's right, but that's not what they were asking for. Okay. I'm not gonna write this flashcard down. That's dumb. Um, okay. Between assignee and sublessee, um, assignee is in privity of estate with the landlord, liable to the landlord. Yeah, I guess sublessee is not in privity of estates. Okay. What is attornment? Attornment is the tenant's acknowledgement of a new landlord. By writing or making rent payments. Subleasee is only liable to landlord if they assume a rent covenant, or yeah, if they assume a covenant. Okay. And I think that was my last flashcard. Nice. Okay. Alrighty, that was a shorter stream. My brain is fried. Thanks so much for hanging out with me, Maury, and anyone else. This one's probably a little bit less exciting. Property law is not exciting. Well, I shouldn't say that. I don't think it's super exciting. I might come back on later. We'll see. But thanks for hanging out. I'm glad your notifications worked today. Um, and I'm sure I'll see you in a chat later, another time, Maury. But thanks for hanging out. Bye, guys.